Hi, my name is Robert Browne, and I'm a partner with Troutman Sanders in the Chicago office. I want to welcome you to the next podcast in a series of podcasts that Troutman Sanders and Pepper Hamilton are producing over the next few weeks to discuss litigation topics that have been brought to the forefront by the COVID-19 pandemic and how business might be able to prepare and respond. In today's podcast, we're going to talk about considerations for limiting liability for manufacturers of masks and other protective gear for healthcare providers and the general public. Joining me today from Pepper Hamilton are Sharon Klein, a partner in the Orange County office, and Judy O'Grady, a partner in the Washington, D.C. office. Sharon and Judy, thanks for being with us today.
Hi, this is Sharon. Thanks for having us on.
Thanks, Rob. This is Judy.
From Troutman Sanders, we are joined by Brett Tarver, an associate in the Atlanta office, and Victoria Alvarez, an associate in the Charlotte office.
Hi, everyone. This is Brett. Happy to be here.
Hi, this is Victoria. Excited to be talking about this topic today.
So Brett and Sharon, can you start off by giving a little background as to how you started looking into these issues surrounding the manufacture of face masks and other types of protective equipment?
Sure, Rob. This is Brett again. So one of the ongoing stories during this crisis has been about the lack of protective gear. From the Troutman Sanders side, we got involved after I was contacted by folks actually at the Atlanta Opera. Their costume shop was lying dormant during the COVID-19 crisis as they had put a halt on all of their performances. So they wanted to use their resources and skills to give back to the community by manufacturing masks and gowns for local Atlanta hospitals. So Victoria and I started looking into these issues to provide guidance to the opera on a pro bono basis as to how the organization could best protect itself from liability in undertaking the project to make the protective equipment. Our project really focused on protective equipment that was intended to be used by healthcare providers rather than protective equipment to be used by the general public. So that's how we got started looking into these issues on the Troutman side.
This is Sharon. The FDA defines PPE as protective clothing, helmets, gloves, face shields, goggles, face masks, and other respirators or equipment designed to protect the wearer from injury or the spread of infection or illness. In essence, PPE is personal protective equipment to be used in a healthcare setting. In addition to counseling on PPE, our health sciences lawyers at Pepper also have been busy advising apparel manufacturers on face masks for non-medical use. For example, St. John Knits, a high-end fashion retailer, was keen on using its manufacturing facilities to help with face mask shortages for people having to go to work, grocery stores, or be out in the community. We are proud to be part of the effort to advise manufacturers regarding liability protections in producing much-needed face masks and other PPE to help bring the general public back to work.
You both touched on protective equipment for medical use versus for the general public's daily activities. Is that a key distinction that potential manufacturers need to consider? And if yes, why is that?
Hi, this is Judy. To answer your question, yes, that is a key distinction that a manufacturer needs to consider before they begin making protective equipment. The product's intended uses shape the regulatory requirements, enforcement issues, and liability that a manufacturer may face for the products it makes.
How can a manufacturer know if the products it wants to produce will be regulated by the FDA or not?
Generally, the FDA will consider a product to be a medical device that falls within the FDA's regulatory authority when the product is intended for a medical purpose, such as for the prevention of disease transmission. Even cloth face masks are usually considered medical devices subject to FDA regulation because they fit that definition. The FDA has, however, drawn a distinction between face masks intended for use by healthcare professionals to prevent the transmission of disease, as opposed to face masks for use by the general public in non-medical settings.
So what Judy just said is right. As an example, if a manufacturer wants to make face masks to be used by the general public for non-medical uses, The FDA would not consider those products to be medical devices because they are not intended to be used for a medical purpose. If the product that the manufacturer wants to make is intended to be used for a medical purpose, the manufacturer will need to comply with FDA guidance on the manufacturing of those devices.
That's great. What resources should manufacturers use to determine if the PPE they want to produce will be regulated by the FDA?
So this is Sharon. The FDA has issued numerous guidance documents on COVID-19 countermeasures, including PPE. As the pandemic has evolved, the FDA has issued additional guidance documents on the same type of products. And this is a quickly evolving situation. We are monitoring it daily for FDA updates and additional guidances. In some cases, those guidances have become less restrictive, and in other cases, the guidances have become more restrictive. Essentially, the FDA is monitoring the market and assessing in real time whether and how their guidances need to be changed. With respect to protective equipment, a manufacturer needs to consider the intended use and the intended users. If the product is intended for a medical use by medical personnel, it is regulated by the FDA. If it is not intended for use for a medical purpose or use by medical personnel, it is not PPE and not an FDA-regulated medical device. Notably, the FDA and other federal and state regulators are proactively taking action against companies that are not complying with their COVID-19 guidances. They are also cracking down on counterfeit products and bad actors looking to profit off the pandemic by price gouging or other mechanisms.
This is Victoria. To build on Sharon's discussion of FDA guidance documents, in addition to guidance, the FDA also issues emergency use authorizations, or EUAs. Manufacturers can also apply for an EUA, but I will let Judy talk more about that in a second. But currently, the published EUAs relate to things like respirators, sterilization systems for those respirators, decontamination systems, air purifiers, and face shields. But for face masks, the FDA has issued guidance. And like Sharon explained, if the mask isn't intended for a medical purpose, meaning it is not intended for use in the diagnosis of disease or other conditions or in the cure, mitigation, treatment, or prevention of disease, then FDA regulations do not apply. But if the face mask is intended for a medical purpose, then you have to determine how the mask will be used in surgery or in the procedure room, for example, what level of protection it's intended to provide, and what materials you're supposed to use. The FDA's guidance provides the necessary standards, like ANSI standards, that masks must meet. The guidance also outlines other requirements like labeling. Labeling has to include a list of materials that come into contact for the body. So for all of those things, reviewing and conforming to the FDA guidance and to know what standards you're supposed to meet is of critical importance.
Thanks, Victoria. Once the manufacturer determines regulatory status, what are some other ways that a manufacturer can protect itself from liability?
The manufacturer has to protect itself on several fronts. First, from a business perspective, with the healthcare entity it's contracting to provide masks to. And then also, second, from a liability perspective with that healthcare entity. And third, from a liability perspective from the end users of the mask, and also for the people that are exposed to the end users of the masks or patients. These sort of liability risks are personal injury or wrongful death suits from healthcare providers, patients, and considering the communicable nature of COVID, maybe their household. So the first piece of the armor to protect the manufacturer is a strong agreement with the healthcare entity. When I was working with Brett to draft the agreement for the Atlanta Opera, I never thought I would be citing to the president's power to declare a national emergency pursuant to the National Emergencies Act, but it is important for a manufacturer to invoke any statute which offers immunities and liability protection. Also, it's important to invoke volunteer protections if that is applicable and to waive all warranties. Particularly, face masks should be accepted as is. And if possible, the manufacturer should have the healthcare entity provide materials, instructions, and then have that entity approve a prototype and get that approval in writing. Now, while the pandemic is ongoing, there's a sense of goodwill and we're all in this together mentality. But in a few years, when that spirit of goodwill fades, people could look to others to blame, and agreements are intended to help protect against that.
Thanks, Victoria. And I wanted to highlight one of the things that Victoria mentioned in the agreement that was crafted for the Atlanta Opera, focused on the volunteer nature, that the Atlanta Opera was making these products for free for healthcare entities, just trying to help with the crisis. So that's a different wrinkle between manufacturers who are switching gears to make these types of products to sell. And that's something to definitely take into consideration when you are advising clients on how they need to approach it. In addition to what Victoria mentioned, as a written document, any agreement that's written between the manufacturer and either the purchaser of the protective equipment or the healthcare entity that they are providing the equipment for is a written document that can reflect that the protective equipment is being manufactured in accordance with the FDA guidances and requirements. Victoria mentioned that some of the FDA guidance documents require manufacturers to identify any body contacting materials that will be used in the protective equipment. So these body contacting materials can be detailed in the written agreement as further evidence that the manufacturer is conforming to requirements that the FDA has set forth in its guidances. Finally, to the extent possible, manufacturers need to check in with their insurance carriers. If they are switching from making fashion products to now making protective equipment, they need to have an understanding as to how their insurance is going to cover them for that change in activities and make sure that they do have the proper insurance coverage in place.
Thanks, Brett. Are there any unique protections a manufacturer can rely on given the current crisis?
Yes, thanks, Rob. This is Judy. There are, in fact, at the federal level, the Department of Health and Human Services has granted limited legal immunity to manufacturers of COVID-19 countermeasures, including PPE, through a declaration issued pursuant to the Public Readiness and Emergency Preparedness Act, commonly referred to as the PrEP Act. Under this, the manufacturers are protected against claims for losses related to drugs, devices, or biologic products that mitigate COVID-19, including products that limit transmission, like masks. But immunity is only available for products that are approved or otherwise authorized by the FDA. Face masks and filtering respirators are among the authorized products, but only if the manufacturer obtains an emergency use authorization or there's a general emergency use authorization for the products, as there is in this case. Manufacturers should note, however, that immunity still requires careful compliance with the FDA's guidance for those products, such as labeling and testing requirements. And then just echoing on what Victoria discussed earlier about how important it is to analyze whether you're going to be protected by these immunity provisions. There was just a news article yesterday that the plaintiff's bar is not happy about all these immunity provisions that are being issued, and is galvanizing and going to use some of their government connections to try to fight some of these provisions or limit them.
Thanks, Judy. That's very interesting. This is Sharon. Additionally, HHS has recently clarified the bounds of that immunity under the PrEP Act in an advisory opinion. And the immunity is really not absolute, to your point, Judy. And in fact, the PrEP Act generally does not excuse willful misconduct. However, manufacturers and distributors will not have engaged in willful misconduct if the HHS Secretary and the United States Attorney General do not initiate an enforcement action against them, or an enforcement action is initiated and then terminated or resolved without a covered remedy. The advisory opinion also clarified that local authorities, including law enforcement, local government, can extend immunities under the PrEP Act, for example, to agreements or requests for assistance.
Thanks, Sharon. And I want to thank Sharon and Judy and Brett and Victoria for joining me today, and everyone for joining us today to discuss this important issue. For our listeners, if you have questions, please feel free to reach out to any of our speakers today, or visit the Pepper Hamilton and Troutman Sanders COVID-19 Resource Center at covid19.pepperlaw.com. Thanks, and have a good day, and stay safe.
These recorded materials are designed for educational purposes only. This podcast is not legal advice and does not create an attorney-client relationship. The views and opinions expressed in this podcast are solely those of the individual participants. Troutman Sanders does not make any representations or warranties, express or implied, regarding the contents of this podcast. Information on previous case results does not guarantee a similar future result. Users of this podcast may save and use the podcast only for personal and other non-commercial educational purposes. No other use, including without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission of Troutman Sanders.